Chief Justice, and may it please the Court, there is no serious dispute that at the time Ms. Laufer filed suit, Acheson provided no accessibility information on its reservation website, thereby excluding disabled people from using its online reservation services and engaging in unlawful discrimination under the ADA. As Congress recognized, when places of public accommodation fail to take reasonable steps to make their services available to people with disabilities, they signal that disabled people are unwelcome participants in the marketplace and contribute to their day-to-day experience of being isolated, invisible, and ignored. If the Court reaches the standing question presented by Acheson, it should reject Acheson's argument that a disabled person does not experience that dignitary harm when she encounters the accessibility barrier on Acheson's website unless she also has travel plans that are thwarted by the discriminatory treatment. For over 6 decades, and most notably in Havens Realty, this Court has recognized that discrimination inflicts Article III injury regardless of whether the plaintiff experiences any harm beyond the unequal treatment. What it means to personally experience discrimination on the Internet is a novel question, but whether the answer is the one we've offered or the one the government proposes, Havens requires a test that focuses on what the plaintiff experiences on the website, not her underlying motive in that experience or whether any downstream injuries result. Finally, I want to return to the issue the Court started with today. Mr. Unikowski and I are both arguing before the Court on behalf of clients that have no legal interest in the outcome of this case. Ms. Laufer, because she has dismissed her complaint with prejudice and will not be bringing any more ADA suits, and Acheson, because it no longer owns the hotel whose reservation service the suit challenged. These circumstances render the case, at minimum, a poor vehicle for reaching the standing question. I welcome the Court's questions.
You started with the standing question, and you spoke of dignitary injury, and in your briefs, I think you focus on stigmatic injury. The government seems to focus on informational injury, and there seems to be a difference in your characterization of the injury here. Would you spend a few minutes and explain which injury are we talking about?
Here we're talking about a discriminatory denial of information, so it's not a pure informational injury. The discrimination aspect of it is important because, as in Havens, it's not just that you're not getting the information. You're not getting the information for a reason that conveys that you have inferior status in society. So it's inflicting a dignitary harm that you wouldn't have from a purely informational injury.
I guess I could think of cases in which denial of injury doesn't go to one's dignity or it doesn't create this sort of a stigmatic deprivation. But it seems as though the government doesn't make that second step to the injury that you're talking about. It focuses more on the information that you are deprived of in order to be able to use or to make a decision about using a hotel.
I think the government's brief does talk about this Court's jurisprudence on dignitary harm and discrimination and the fact that the Court has never required any downstream consequence for a discriminatory injury, and that's certainly the approach the 11th Circuit took on this issue.
I agree with you